Hi, my name is Lindsay Tenbridge, and the topic I'm going to be talking about today is competence to consent to a search and seizure. So this is a media link that I'll link below as well in the comments, but it's just a crash course video on search and seizures. It's a much more in-depth look than what my presentation will go into, and it goes into the different types of searches, seizures, and where they can take place. Decisional competence. So competence to consent to a search and seizure is a decisional type of competence, so it's competence to make a particular decision. This is an important concept because human dignity requires respect for individual autonomy unless reasons to violate that autonomy exist. With decisional competence, the state does not enact parents' patrie unless the individual lacks the ability to make the specific decision or to perform the specific act at issue. So the court or the state will not act as a parent for an individual unless they lack the capacity to perform a certain act at hand. Competence to consent to a search and seizure is one of the first decisional competence issues that could arise in criminal litigation, and most often it is the issue that is raised prior to trial at a suppression hearing. Search and seizure is a Fourth Amendment issue. Anything with search and seizure deals with Fourth Amendment. The Fourth Amendment states the right of the people to be secure in their persons, houses, papers, and effects against unreasonable searches and seizures. If found unreasonable or violations occur, the evidence or fruits of the unlawful behavior is generally excluded from the prosecution's case. So if a police officer conducts a warrantless search and just found with his police action to be in violation, then all evidence will be inadmissible at trial found during that search. The issue most likely to require clinical evaluation is if the individual who consented to the search and seizure was competent to do so. Search and seizure. So a search is a search. It could happen body, person, in a house, home. A seizure occurs when an officer, by means of physical force or a show of authority, terminates or restrains his freedom of movement through means intentionally applied. A seizure can occur in a person's home, vehicle, or business to find evidence or fruits of a committed crime. If no search and seizure has occurred, then issues of the Fourth Amendment do not apply, and nothing with the Fourth Amendment will apply. Unreasonable. A search and seizure is not unreasonable if the individual voluntarily agrees. An incompetent individual consenting to a search and seizure is one way police action can be rendered unreasonable. Police officers can conduct search and seizures without probable cause if the individual voluntarily consents to the search. Detaining an individual, even without cause, is not considered a Fourth Amendment seizure if the individual voluntarily consents to being detained. So basically, just if the person agrees to saying yes, being detained or being searched, then police action is fine. Voluntarily. The United States Supreme Court has held that for Fourth Amendment purposes, an individual's consent can be voluntary even if the individual is not aware of their right to refuse consent. With this justification, the evaluation of an individual's competence to confess to a search is based almost entirely on the extent to which the police coerce the individual. The individual's knowing of the right to refuse is a secondary issue, if any or at all. So even if the individual has no idea that they can say no to being searched and think that, or is just afraid of the backlash, then that's no protection with the Fourth Amendment. And basically, just if you don't know, that's on you with like a lack of awareness of your rights. Consent versus coercion. The Supreme Court has often identified the most significant exception to the warrant requirement of the Fourth Amendment is the consent search. In circumstances where the police lack probable cause to arrest or search, valid consent may be the only means of obtaining important and reliable evidence. Given this justification, one would think that courts would be very precise to assure that consent was properly given and at the very least voluntarily granted by a competent individual, when a lot of times that is not the case, where majority could be like coercion by the police or just like talking them into being searched because they know that they are not aware of their right to refuse. Coercion. Warrantless searches made when officers knowingly do not have probable cause, even if they went to obtain a warrant, creates a bigger challenge as officers bargain for consent and, like I said, like talk them into being searched. Majority of police encounters, individuals feel threatened to comply and not free to decline. In many consent searches, the individual feels that any attempt to deny the search request would be taken as refusal to cooperate and met with unknown negative consequences. Police officers are not required to tell an individual of their right to refuse consent, which is very different from Miranda warnings, where police officers are mandated to tell them of their rights to remain silent and to protect themselves from self-incrimination. Reviewing issues of the Fourth Amendment search and seizures, courts look at the totality of the circumstances to determine the voluntariness of the individual. So, with looking at competence to consent to search and seizures, every case is different. Consent will not be regarded as voluntary when the officer asserts his official status and claim of right, and the individual yields because of these factors. So, if an officer shows authority or force, then that will not be valid for consent. However, when consent is obtained through deception or of an undercover, the individual has assumed the risk that another would betray him, and evidence obtained through deception is admissible. So if an undercover cop does the trickery himself, then it's fine because the individual basically has taken the risk that their person they're talking to is telling the truth, even though there's the possibility that they are not. So a lot of in the chapter, there was a lot of studies on consent searches and how different people will react depending on the type of questions it asks and how it's worded. So in a simulated search scenarios, Kakiro found that the search request phrased in an interrogative fashion, would you mind, for example, would you mind if I came in and looked around, resulted in higher perceived choice than did declarative requests. For example, I would appreciate it if I could come in and look around. However, the first type of request resulted in a higher likelihood that entry would be granted and that questions would not be asked about the objective of the police and why they are there. This study also found that the more detail the police provided in their request about their objective, the less likely it was that the person would feel free to ask the police to leave once consent was given. Another study by Lichtenberg found that people consented to searches from the police for one primary reason, which is fear of reprisal if they refused. Many and majority of individuals are unaware of their right to refuse, which the Fourth Amendment does not protect individuals against if they are just unknowing. Subjects who did understand of their right to refuse expressed no faith in the law being followed up by the police. And again, the evaluation of a person's competence to consent to a search and seizure is focused almost entirely on the extent to which police coerce the consenter. So when looking at competence of the individual to consent to a search and seizure, basically you're looking at all the police activity and see if they deceived or did any violations of trying to get a search and seizure. My discussion question is, do you think that police officers should have to tell individuals of their right to refuse to consent to a search and seizure? And why do you think this scenario is different than Miranda warnings, where officers are mandated to tell individuals of their rights to remain silent and not self-incriminate? And these are my references, and thank you.